All right, we'll go ahead and get started. I don't know if the microphones are very loud or if they're working, so I'll try to project and speak loud. On behalf of our co-sponsors, the NGO Mining Working Group, the Greek Orthodox Archdiocese, Mercy International, and Vivat International, welcome. And thank you for taking time out of your busy schedules to be here today. The denial of human rights and property are intrinsically connected. This is especially plain to see in land and water grabbing by extractive industries. It benefits transnational corporations while rendering communities poor and disenfranchised. Land and its resources are important for all humans, but they have a particular significance for indigenous communities. Access to land and water is not only vital to health, sanitation, shelter, and life, but also to keeping the social fabric intact. In light of the 2030 Agenda for Sustainable Development, land and water grabbing continue to be a barrier to eradicating poverty. As people are displaced because of land and water grabbing, their economic empowerment is diminished and they regularly plunge into poverty. The Sustainable Development Goals provide an avenue to address these inequalities, which we'll be discussing today with our esteemed panel. The first speaker will be the Reverend Nicholas Varla. Father Nicholas is a member of the Society of the Divine Word and of Vivat International. He is originally from Odisha, India, and belongs to the Oraon indigenous community. Seeing the situation of the local population, Father Barla decided to engage in social justice and development issues in 1994. He's involved in the protection and promotion of indigenous peoples' land, forest, water, and environmental rights, and advocates at the local, state, and national levels. He is active within civil society, grassroots advocacy, and people's movements in India. Father Barla currently coordinates all 62 tribal groups in the Indigenous Peoples Forum, Odisha, and Tribal Coordination Front, India, to advocate at the national level. His mission is to represent the voice of the voiceless. Father Nicholas?
Good afternoon to all. Thank you for having called and organized this meeting here in UN. In fact, I was here in 2008 in connection with the indigenous people's issues, and after listening to different dignitaries and different thoughts, I went and I walked in my state and in the country in India, and again because of Vivat International, I got this opportunity to come and share my experiences here with you. And this is my language, Adivasi Johar, so greetings to all of you. As we are seriously considering and discussing on social protection, eradication of poverty, and no one should be left behind, I think very big challenges in my country, in my situation, in my villages I see, and land, forest and water, these are the very essence of the indigenous peoples in the villages. I think not only in India, all over the country, those who are living on this land, forest and water and agriculture. And therefore, in my view, I have put some of my experiences and observations. Just to give you about understanding about India, we have 30 states, and total population we are say 1.25 billion. 1.25 billion. And right side we can say all indigenous people are in almost in 7 states of the country, and 104 millions, that is 8.6% of the total population of the country. And you can see almost 600,000 villages. Yeah, so many villages are there, and the tribal. Tribal, I am using tribal, Adivasis and indigenous community. So these 3 words are there, so kindly understand it. Um, the literacy level we can see very low, and also the children are underweight, and many they die in their early stages. So you can see the numbers and all, and you can imagine the situation that we in India and in my state Orissa that we are facing. Yeah, this is all because of the, suppose in the government way, suppose we think, then definitely there is a lots of gap in the infrastructure in the rural area, and particularly in the indigenous people area, because they are living in the forest on the top of the hills. So all this, the problems like irrigation, godowns for grains, cold storage, all these things we lack. Nothing is available in our villages. Road, communication, transport, all these are also not there. Even telephone and internet system, all these are also not available. Schools, healthcare, drinking water. So sometimes we cannot imagine in the villages. So such type of situation that we are having in the country. Next. And therefore, as we must have heard this statement, indigenous peoples face systemic discrimination and exclusion from political and economic power. They continue to be overrepresented among the poorest, the illiterate, the destitute. They are displaced by wars, extracting resources, and environmental disasters. Indigenous peoples are dispossessed of their ancestral lands and deprived of their resources for survival, both physical and cultural ways. They are even robbed of their very right to life. It is therefore very critical and essential that the rights and needs of indigenous peoples, their developments are discussed and addressed in the social development agendas that we are having here in UN level. One thing, I like to share with you that though we saw 8.6% of the indigenous peoples, they consider themselves indigenous people of India, but unfortunately the government of India, they deny it. So that's so many of the rights that the international level that is declared, and in some of the documents India government has signed, but in spite of all these things, we are denied of the rights. Basically, I am working with that Santali, Ho, Kol, Gond, Bhuya, Orao. So all this, we are, as already we saw, more than 705 indigenous groups are there in the country. And in my state, Orissa, we are over 62 types of indigenous people. So to bring them together and to work together for their development is really a very challenging. Yeah, this is the picture of the country. The green part, right side, those are the thickly populated with indigenous people. Over 75% people are there, and little bit yellowish color. They are up to 50. You can see, and that's so in the central part of the country, mostly indigenous people are there. Yeah, these are the indigenous peoples in the entire country, thickly populated, and in course of time we will see they are also mining, thick forest, and violence are there. Yeah, this just I have written some of the words. This Nagda village, nobody knew about this village. In the month of June, suddenly about 19 children within a month they died due to malnutrition. Then it came in the paper and media. Then the government of Orissa started thinking, and so much of discussion was there. This is one. Next one. This is another one. Mr. Dhanomasi, due to lack of ambulance, he had to carry his dead wife's body up to 10 kilometers in the forest because there was no road, no ambulance, and so no health system. So this also drew the attention of the entire country. Next one, yeah. Here in the month of September, October, I had gone. In this particular district called Malkangiri, according to government, they say about 130 children died due to unknown disease within 1 month. But according to people, when I went and I asked, they said more than 500 to 600 children died within a month with unknown sickness. So this type of things are the indigenous community they are facing in the forest, and the realities are not coming out. And this is another incident. It happened in the month of July 8th, where all this area thickly forest area and mining area. So one fine day in the evening, about 7 o'clock, the police fired at them and killed 5 people on the spot, injuring 7. And they say that extremist group. So they killed them. Then afterwards they declared that they were extremist groups. But they were from this spot is just 1 kilometer, not even 1 kilometer, 500 meters away from their village. So such a cold manner way they killed them. Yeah. So this man is we had a big demonstration against the government, and he's one of the indigenous community member. His daughter-in-law and his grandson, they were killed. Then we asked him to explain, and he met the police and army. He met and he talked to them, so he knew the things. So he was explaining to the entire people. Yeah. So this type of things are happening in the dense forest, in the mining areas, and so we need to understand how our development and SDGs should take place. Yeah. So in a way, wherever mining and forest are there, this indigenous community is there, and they are the direct victims of the entire development process. So we need to understand this one. Entire mining, let it be mining or industries or the clearance of the forest. So it is the indigenous communities, they are the victims directly. Yeah, such a beautiful forest are there with so nice biodiversity, but all are extracted, and entire hills and forest are simply cleaned. Yeah, also with this type of picture I am showing, because it is not only the wealth of the people, but total their culture, language, their faith, their whole life system is destroyed. Because afterwards, these beautiful people, they have to go to find out their livelihood either to the towns or cities as slum dwellers finally. So their entire dignity and their identity and whole culture, language, everything is lost. So we need to understand all these things. Yeah, next. Yeah, this is also the cultural part. Yeah. Next. Yeah. So beautiful resources are being distracted because of the development concept. Yeah. In our area, see, very rich area in terms of mines and minerals. So coal, iron ore, bauxite, and so many like this. But they have government has given already more than 100,000 hectares of land, forest land, for the mining purpose. So means you can imagine how the entire area, the environment disbalance will be there. This is one of the statistics that I am putting forward for your consideration. See, in the name of development, say left side coal and dam industries, sanctuaries and others like that, how many people displacement and how many people the government and companies they have rehabilitated them, and how many are on the backlogs. So you can see. So it shows hardly 30 to 40% people are rehabilitated, and remaining 60%, 70% people are just left. So no government, no companies, no one bothers about this community, this group of people. So this is the reality when we are talking in terms of mining, displacement, rehabilitation and policies. So people are just thrown out like. See the pictures we can see, all the minings I was explaining you. So these are the mining area of the country. So those three states, Jharkhand, Orissa and Chhattisgarh, I was explaining. So these are the areas where thick forest and mines are there. Yeah, see beautiful greenery, forest and hills becomes like this, black. Yeah, yeah, minerals and natural resources are widespread under people's land, in fact, because whether it is forest or agriculture land, but people have been using those land. And one fine day, this company and governments, they come and just they take it away and they start for their purpose. And side experience is that government's control is limited because the political will is with the economic purpose. Development of the country, development of the state, development of the districts, that is the way they speak. But development of the local people, they do not speak and they do not bother about that. So that is a side aspect of entire this type of extracting industries. And the central government and state government, they do not take the responsibility. State frames rules which works best for them, not according to the people. So this way how the illiterate, so-called illiterate, innocent and harmless people, the indigenous communities, they struggle when this type of development activities are taken place. This is another important data that in those districts the mining extractions were there and people should have been rich in this area. But we see the human development index, the literacy rate, how low it is, the below poverty line. So in this area, the people are very poor. They should be the richest people because of their mining and because of their resources. But these are the people, they have no healthcare system, they have no education, they have no livelihood. Sometimes livelihood also very difficult to get. They have to go at least 5 kilometers to fetch drinking water. So this type of situation these people they face. So this is a very dichotomy of the entire development process. Yeah, see, one of the statements, it is given by one of our Chief Justice of Delhi, Dr. A.P. Shah. So he says, these Adivasis or the indigenous people are always exploited. So I happened to be in Delhi, so this had come, yeah. And that inequality is very much in India and in my state. So 20% of the population are rich and 80% of the population are very poor. And it is interesting that same 20% of the population, they own 80% of the wealth, and 80% of the population, they own 20% of the wealth. Recently, just in the month of this January only, in one of the papers it came that 1% of the population possess 58 of the country's wealth, just on this January. And it was studied by Oxfam. So all these are very, how the country in terms of distribution of the wealth, how it is, and why the people are richer, why the people are very poor. So it is very clear because there is no proper distribution of the wealth. There were so many revolts by the Adivasis or indigenous communities. We can see from 1765 onwards this type of revolts, and still it goes on because of this type of extracting and taking away their land and their wealth. So they continue to do it. Yeah, next. So these are some of the incidents that have taken place in the country where many are arrested and so many things. Yeah. These are the extremist area. So those mining area and forest area, tribal area, and also disturbed area. So, yeah, these two big companies we had fought. One is Vedanta, you must have heard about it, and one is POSCO. So we had to fight it for almost 10 to 13 years. But the people fought, and the international community also they supported. So many NGOs, so many struggling groups, so many supported, and we have won in against this both company, and we have protected this forest. So this is a very good example that we have. Next. Yeah, people are living with this type of leaves, betel leaves, because betel leaves we call, and a company wants to make their own industry and all. Next. This is forcefully how they demolish the government. Forcefully they demolish their vineyards this way. And this was the scenario that how the children, the women, the men, all they come forward for the protest to protect their lands and their forest and their area. Next. Some of the villages, like in Chhattisgarh, 645 villages are displaced, and very sad things are there. So many of rapes of the women. In 1 month, it was 40 cases were there, and many people are in the jail. So very sad scenario is there, in particularly in Chhattisgarh state. These are the people how the government in the name of Salwa Judum. So these are all illiterate, or they might have studied just 4th or 5th standard, and the government made a group to defend the extremists. So these are all the indigenous boys, and extremists are also indigenous people. So it is fight between both, the same people are fighting, same brothers are fighting. So that's how it has become like. Next. 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 Let us go ahead. Time is not there. So really, the people are facing really challenging situation in those areas. Next. Next we can see is go ahead. Maybe how development we like to see. Development is a human rights based approach, taking into account issues of equality, participation, sustainability, and development with culture and identity. I think this is how the Indians people, they like to see their own development, and not only economic. So this is very important to understand. Next. We have very good protective laws are there, but suppose all these laws are implemented and properly, the government and people they abide with this, I think the people would be very nicely, they would develop, they would be very happy. But unfortunately, all these laws are not being implemented, and people are suffering. So which is very unfortunate. But the government itself is violating all these laws. So which is very unfortunate. Next. This is my state where we are trying to work it out in different way in different districts, and bringing all the 62 tribal groups together. Next. So all this wealth and extracting industries, so finally make the people helpless and useless and worthless. So nothing is left for the people. So all types of violations, everything is taking place. So this way how we like to, based on the same some of the laws, we like to organize the people, and in village wise, we call it Gram Sabha, the village government. So that way how we like to organize each village, and we like to bring the people and give them confidence and empower them, so that they themselves become defenders for their land, their forest, and their own wealth. So that's how we are thinking and we are working. We have beautiful constitution, with the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice in social, economic, political, liberty of thought, expression, belief, faith and worship, and equality of status, of opportunity, and to promote among them all fraternity like this. So, but unfortunately, people are suffering. So nothing is fulfillment. Very unfortunate. Yeah, next. Yeah. So yeah. Next. Yeah. So these are some of the basic inbuilt system of the indigenous groups, their communities. They have their own system of caring, sharing, and community living. And suppose we strengthen them through their social system plus this type of legal system of the country, I think that way how we can protect and develop the indigenous communities very well. Yeah, this is economic, how we like to see. Next. Cultural also, yeah. Women and children, elders, yeah. Yeah, so this way how self-governance in a way we like to see, and we need the structure could be changed little bit with the laws and all. And that's so we foresee, we are very positive that suppose we work out positively, definitely we can protect the land and forest and also the people, and rightly we can develop the people. So that's how we believe and we are working on that. So I will stop here. Thank you very much for this one listening.
Thank you very much, Father Nicholas. And you were able to paint a picture for us about how the indigenous rights are diminished, how mining companies are exploiting the people as well as destroying the natural resources. You began to give us some examples that human rights approaches to development rather than just economically centered is one solution. Implementing existing laws is another, and there will be some time for discussion at the end where we might be able to flesh that out. Our next speaker will be Father John Paul Pezzi. Father John Paul is an Italian native and has a wealth of experience both as a missionary and as a journalist. He was a freelance journalist and editor of a magazine about African politics and culture before managing a radio program in Ecuador and then another magazine in Colombia. He was a missionary in Burundi and later served as a parish priest in the Democratic Republic of Congo. He became involved in justice and peace issues during his time abroad, especially after experiencing 2 wars firsthand in Africa. After returning to Rome, Father Pezzi recognized that land grabbing would soon become a major international issue and began working with Vivat International in the United States. He promotes awareness on land grabbing and manages a multilingual blog on justice, peace, and integrity of creation. Father Pezzi presents all over the world and continues appearing on radio programs to raise awareness about land grabbing. Father Jean Paul, the floor is yours.
Thanks and good afternoon. I'm a good journalist, but I'm bad in English. So I just try to summarize some few ideas on land grabbing, picking them on the training I prepared of 10 days. 24 modules, so to summarize in 50 minutes is quite difficult, but we try. The first point is where to situate always when you talk about Earth, where we put the question. We call Earth as a part of the universe. The Earth is the source of life, the mother that nurtures us. The Earth is our common home. The Earth is a territory where all struggle and search of power is located. But when you talk about land grabbing, it's concerning the earth as a field, as the land where we cultivate to get in food. So what is land grabbing? The term has been used before, but today is referred to the rush for large-scale land acquisitions since the 2008 world food price crisis. The crisis prompted food security fears and the newfound economic opportunities for agricultural investors and speculators. These land acquisitions follows two paths. They're buying or leasing in developing and developing countries the land. It is done by whom? By all, by foreign governments, domestic and multinational corporations, investment funds, universities, Department of States, speculators, and also private persons. We need to assess whether, when there is some land trade, is it a problem of honest business on land or land grabbing. Because land on agriculture, trade on agricultural land has always existed and played a positive role in creating jobs, services, infrastructures, and also in improving the livelihoods of peasants and promote rural areas. Honest business, however, is done when transparent framework is assured, when the agricultural land is managed responsibly and used for primary purpose of producing food. So what causes land grabbing? There are, in my point of view, two main causes. The visible one is the driver coming from the food crisis. Since 2008, prices of produces, wheat, rice, corn, and other cereals increased, and countries with a large population, such as China, South Korea, and India too, or with a shortage of agricultural land, such as Saudi Arabia and Emirates, felt concern on food security. And so they sought how to produce food overseas, especially in developing countries where production costs were lower and where land and water were more abundant. But the second driver of land grabbing is the market. Today, all the crash and struggle occur in the market. Culture, let us think about Coca-Cola and McDonald's. In economics, accumulation of goods and capital, even weapons, trade, transaction of goods and finances, and even people, labor force, human trafficking. And all the assets that feed the market are found in land, in territory, water, minerals, roads, housing, even working people, but above all, food. And the main point is food when we talk about land grabbing. If we empower our food, said Alexander Spivak, we can break the chain that has tied us to our present condition. So, where does the phenomenon occur? Most of these land agriculture investments are in the global south, in sub-Saharan Africa with 70%, in Southeast Asia and Latin America. But nowadays, the last 5 years, the phenomenon occurs also in Europe, above all in East Europe, and also in Latin America. Let's think just to the Dakota pipeline. And government with economic power seek to ensure directly food for their people. We can gather states who traffic lands in Africa, Asia, Eastern Europe. India has a large agriculture project in Brazil, and Brazil in Paraguay. South Korea tried, and they brought about the coup d'etat, to buy half of the island of Madagascar. And the corporations seek again growing crops for exportation and biofuels. The land nowadays is object of greed. It is not a Mother Earth, the common house, it is just a good. A good that means to get money. Today, we have to realize one point, that after the end of colonies, all land belong to someone, state or private people. And so, when the people try to get a land, they have to show up a good face to be good in politics, economics, and culture situation. And this brought about this phenomenon called land grabbing, just to quench the greed of land. Why? Why land grabbing is an ambiguous issue. Land acquisition always are made through investments contracts that are formally correct. The people, states, and corporations try not to violate national or international laws. They try to use a legal space where there are not specific rules. However, the contract they made often do not respect human rights, do not recognize the principle of free, prior, and informed consent, do not assess the social, economic, and environmental impact. They do not respect the clear and binding commitment on the use of land to produce food, and in the benefit sharing. Often, they do not include a democratic participation of the communities already using the land. And the main tools used in the land grabbing is the long-term lease contract, where to buy land is not easy. And that lease contract are predominant where the land system is based on informal or traditional laws that are recognized locally but not internationally. So when the foreigner come in, protected by the government, the local communities' land rights are not guaranteed. And this brings back to a main idea I found living 3 years in the forest with the pygmies. Land is not important. What is important is what you can find on the land. Water, minerals, roads, and so on. You can destroy land provided that you save what you're looking for. At the core of this problem, there are consequences on food and hunger. Food, you know, is a fundamental right denied to a quarter of the world population. 860 million people go to bed hungry every day. And nowadays, food reserves are falling, and many countries do not have food security for the future. And for this reason, food has become nowadays a rivals of oil for power and economic security. No food, no freedom, no life, no way to resist to the power. Agricultural land that was supposed to be used for food is used to produce agrofuels or food for exportation, destroying family agriculture that nowadays ensure 76% of food in developing countries. So the prices of agricultural products rise, and this leads to possess even more land. People are left with neither land nor food and displaced from their fertile lands. Even sacred places are desecrated for agriculture, mining, and other projects. Peasants and indigenous communities are condemned to poverty and even to die culturally and physically. The central issue so are agricultural land that should be for food. Land is essential for food sovereignty. Land should aim at the welfare of people as a whole. Land trade should respect family agriculture, and agricultural land should serve first local community and not exportation and biofuels. The right to use land for food is natural, primordial, and universal, because getting food is a basic human right. But race and race for land is something very different. This day rush for land proved to be an increasing pressure on land upon which depends food security of millions of people. Investment through expropriation, deception, violation, and the extraction of human rights and even life is the tool to get land. And millions of people are left with no crops, no food, no home, no justice, but just poverty. And thousands of communities live in conflict, 200 only in Latin America. So the land grabbing issue is a new phenomenon, not historically, but because of the huge is going on nowadays for its extension, reach, and continuity. At least 50 million hectares of best agricultural land around the world, especially in Africa, have changed hands during the last decade. Some sources speak up of 227 million hectares, an area wide as Northwest Europe as a whole. A powerful economic elite concentrate land and dedicate it to business for projects, logging, and minerals, and to speculate about food. And the peasants, without having been informed, are dispossessed of property, forests, and water access that ensure their survival. What do they receive in exchange? Offerings. Offerings of infrastructure, healthcare, education project, access to market, but all this without any security for compliance. Let us see just an example. In Africa, $25 billion have been invested in land traffic, and the figure is going to grow up day after day. 60 million hectares of farmland have recently passed into foreign farmers in 20 African countries. This land would suffice to feed 50 million African families. About 1,100 agreements, the trade agreements, have been examined, and half are in Africa, affecting 67 million hectares. In 2009, bids for 56 million hectares of arable land were announced. The most covered land in Sub-Saharan Africa, Mali, Sudan, Mozambique, Liberia, Tanzania, Ethiopia, Zambia, the Democratic Republic of Congo, Kenya, and Senegal. And who causes land grabbing in Africa? You can say everyone. European Union, China, India, Arab countries, Brazil, wealthier African countries such as South Africa. Land grabbing impact on natural resources produce poverty. First of all, in agriculture itself. As you know, agriculture is to produce food by simplifying and accelerating the process of nature. Nature ecosystems, complex and organized, keep going on by autonomous sustenance and reproductions thanks to biodiversity. They do not rely on external inputs or management. Biodiversity gives fertilization, pest control, pollination. Instead, land grabbing aims to monoculture that lacks biodiversity, renders the landscape vulnerable to pests, diseases, and extreme weather. It depends on external inputs, fertilizers, agrochemicals, toxic, irrigation, and machinery. Monoculture provides high yield for a short time and at high socio-economical cost, and steal land from family farmers. Second, land grabbing is the way to water grabbing. The investor of land come into bloody conflict every day with people for water access in the countries already thirsty. The statistics say that the water availability in 1950 was of 17,000 cubic meters per person. Today is down to 7,000 cubic meters per person. And this means that the people are looking for water. Each year, 60,000 square kilometers of arable land is transformed into desert due to mining and monoculture. Since 1950, more than half of the forests have disappeared. Yellow alert even for the Amazon forest. This year, just 2 weeks ago, Living Planet published the report on 2016 saying biodiversity is threatened. The document states the situation of our planet about biodiversity, ecosystems, the demand of natural resources, and pointed out that the species of vertebrate animals populations, mammals, birds, and fish, have declined by 58% between 1917 and 2012. Fresh water species drop have been of 81%. The earth become much less hospitable for all of us. During the last 50 years, we have crossed the border, they say the scientists, from Holocene to Anthropocene. I don't know if you don't know these two words. You can talk about after. Beyond engraving, so there is a plan to control the world food, what to grow and what to eat, and who has the right to eat. Monsanto and other multinationals claim to have patents of seed. It is a time bomb for humanity. And if you go on, you can find that the land grabbing is one of the causes with others that push the climate change to becoming a growing problem for all the humanity. Thanks to monoculture, trees have been cut and are cutting every day. The trees are the source of shade and air balance. Now the worms are increasing the heat of the earth. And housing. The land grabbing pushed people out of the space where they were living. And the people, rural people, leave land in the hands of the people who are destroying the natural biodiversity and natural way of living of the nature. What can be done to address the land grabbing issue? There is a work for everyone, for governments, investors, aid donors, civil society, landowners, and all that starting to work above all there where the land is needed for the food of the people. Supporting above all family farmer and invest in rural area and local market. The government and the corporation need more transparency in what is a trade land and strengthen the system that protect land tenure of peasant and small food producers and protect above all this common resources shared among communities. Above all, where there is the tradition that the community of farmers, fishermen, and other category of people share the same land. Good opposition opposing land grabbing is also coming from everywhere. United Nations, FAO, African Community, and the European Community are issuing every day rules and laws that have one weakness. All are voluntary. you can see that civil society, NGO, churches, grassroots organizations launch actions, propose documents, struggle even to shed blood for that cause. The weakness is the lack of coordination and overall strategy run all together. You can see this happening in the conflicts in Cajamarca, Peru, in Guatemala with the gold mine, and you can see also activities coming from everywhere. Viva International, for instance, are promoting this type of seminar or workshop, or as we call it, training on land grabbing. Myself, I've been in Peru 5 times, in Guatemala. I'm going very soon to Bolivia and Ecuador, because you have to make the people aware in the root base what is going on. The university students in United States were two cases. The Iowa State University that have to draw from land grabbing in Tanzania, and the Vanderbilt University that divested from land grabbing because of the action of the students. Local community also are working. You can see in Uganda Land Alliance, ULA, and Cajamarca, the community are disrupting corporation, cutting and buying the small piece of land, crossing in the mining field of the companies. In Guinea, the women grow potatoes. You say, what is that answer to the land grabbing potatoes? Because the African culture says that when the crops on the ground, no one can touch the land. So having potatoes all the way in the ground protect the land. So there is a lot of activities going on in the world. What is lacking is a global strategy needed with action and the participation of all the people. Concluding, you can see that there is also good success in promoting the free, previous, and informed consent. You can, the case in Bolivia, we have a case in Guatemala, one in Brazil, one in Indonesia, and personally, I publish in the website of England called South World Net, in the section of advocacy, every month an article about one good practice that can go and be used to promote the action. And in my personal blog, Justice, Peace, Integrity of Creation, there is a section called Bibliography, and there, if you look for good practices in the key section world, you can find a list of good actions going on in the world. Now, closing, if you like to have more information about this problem or documents, I can provide you after. In my blog, you have an ambiguous activity, an introduction of 10 pages. You have a user bibliography of 2,299 entries, and a presentation of land grabbing promotion. And other documents, a paper we presented at Viva here in the United Nations on land grabbing and conflict, and the book published in Italy by a friend of mine, Food and Land, after the exposition of food in Milan, and the land grabbing in Africa, a PowerPoint they provide to me, and the train on land grabbing of 10 days I prepared in English, Spanish, French, and now in Italian. All is free in the name of God who provides the land for all of us.
Thank you, Father John Paul. You gave us a great overview of what land grabbing is, discussed some of the issues which include the legal ambiguity, the large lease contracts, the government protection of the investors over the local populations. You talked about the core issue being food security. and give us some various solutions, which include local and microeconomies, as well as needing compulsory policies. Our next speaker is Ms. Cristina Gioreas. Cristina is the chair of the United Nations Practice Group at Foley Hogg LLP. She represents states, private entities, and individuals on international disputes and public international law, and also advises states before the UN and its bodies. Ms. Gioreas is an elected team member at the Council of Foreign Relations and has served as an adjunct professor of law at Fordham University School of Law. Ms. Gioreas received the Partners in Justice Award in 2013 and 2016 for her work on human rights cases involving the former military regimes in Somalia and Chile. She has been recognized as a distinguished lawyer in Legal 500, Chambers, and the Global Arbitration Review. Tina?
Thank you very much, Nick, for that kind introduction, for chairing the panel here today. I'd also like to take this opportunity to thank the organizers and sponsors for putting together a panel on such an important topic. We heard today some very compelling testimony from civil society. We heard from Father Nicholas on some of the direct effects felt in his communities as a result of land grabbing and deprivation of access to water, and the effects that that has on poverty. And we heard from Father John Paul, another member of civil society, on the direct effect that land grabbing has on local communities and the need for a global strategy, and the role that in many ways investment treaties have played in inhibiting the ability of states to properly regulate the environment. I'm going to take the discussion in another direction, which is to talk about the legal framework that in many ways enables land grabbing or facilitates it, because it prevents states from being able to properly regulate in the public interest. So I will discuss first, I'll explain what these treaties are and what effect they have had for local communities. I will outline ways in which it's been problematic and actions that states can take to do something about the system. So the issue of access to clean waters is, as a strategy to alleviate poverty, is one that's very crucial, and it's in line with the 2030 SDGs, in particular SDG 1 and 4. In more recent years, states have made efforts to counterbalance their right to regulate with the interests of foreign companies. In the 1990s, there was a wave of privatizations around the globe whereby states entered into what are called bilateral and multilateral investment treaties in the hopes of drawing in foreign investment so as to provide development in their countries. But what happened at that time is that a lot of these deals were not fair deals, and the states didn't really realize what they were getting themselves into. And in more recent years, states have made efforts to try to renegotiate these agreements and strike a better balance. But with the investor-state dispute resolution system and with the text of bilateral and multilateral investment treaties and how they've been expansively interpreted, it's really prevented states from being able to properly regulate in the public interest. So we've been hearing a lot of talk in the media these days about multilateral investment treaties. That's primarily been in the context of the U.S.'s potential withdrawal, or their actual withdrawal from the TTIP and TPP negotiations, as well as the possible withdrawal or termination of NAFTA. But what's been missing from all of this discussion in the media about these investment treaties is a discussion about how developing states have been negatively affected by them. And this has been a topic before the Sixth Committee here at the UN, and it will be a topic before UNCITRAL, and it's a very important subject to really addressing the root cause of why we are in the situation that we are in many of these communities that we heard about today. So to provide you with a little bit of background of what are these treaties, bilateral and investment treaties are treaties between two states, and multilateral treaties between 3 or more states. where the states agree that they're going to provide certain protections to each other's foreign investments and foreign investors. So for example, a company incorporated in one country and one in another, they're agreeing to provide protections to each other's investors. And these protections relate to the conduct of the state acting as a sovereign. And when I say state, that means the centralized government, it means subsidiary governments, it means courts, police, anyone who's acting under state authority on the ILC Articles of State Responsibility. And although these treaties, as I mentioned, that were entered into in the 1990s, they aimed at encouraging foreign investment, there wasn't really much jurisprudence or precedent about how these clauses were going to be interpreted. So these treaties were basically drafted by developed states and signed by developing states, not knowing the consequences, and without a body of jurisprudence indicating how these treaties, what they actually meant. States signed up to them not understanding the dramatic consequences that they had on their ability to regulate. So these developing states didn't anticipate that signing onto a treaty that tried to promote foreign investment could possibly lead to them having to pay out millions and even billions of dollars to foreign investors if they decided that they wanted to do something about issues of poverty, to do something about contamination of water, and to properly regulate their environment. To date, there are over 3,000 bilateral investment treaties in force all around the globe, and they vary in their terms. Some are more expansive than others. But although these are treaties between two states or two or more states, what the text of the treaties do is they give the direct right to foreign investors to bring a claim against a state before arbitration in the World Bank or ad hoc arbitration. So again, no investor is a party to this treaty. They didn't sign the treaty. It's a treaty between two countries. Otherwise, it wouldn't be a treaty if it was between a private company and a state. It would be a contract. So the treaty is between two or more countries, and yet within that treaty, it provides investors incorporated in one country the opportunity to sue the government before the World Bank or other arbitration forum if their conduct impedes on their investment. And I'll get into the specifics of what exactly that means shortly. Over time, investors have used these treaties to bring claims against states, or they've used the treaties to threaten states into, in many ways, into submission where the state is not able to properly regulate in the public interest. So the law that governs these treaties is international law, and as such, the treaty is interpreted in accordance with principles of international law. But as more and more cases, to date there's something like about 500 or so cases that have been filed under these treaties. And as more and more cases have been filed and decisions have been issued, although no decision is binding jurisprudence, it's persuasive jurisprudence, many tribunals often take guidance from or feel compelled to follow the decisions of prior tribunals. And sophisticated corporations have in many ways co-opted this arbitration system through the appointment of arbitrators who they know had a particular view of foreign investment and who had a particular view on how to interpret these clauses. And those arbitrators have interpreted the clauses in an overly expansive manner, in a manner that no state had any idea, none of these developing states had the idea that what they thought was essentially a symbolic gesture of creating a stable investment environment would actually give rise to such liability. So although no two treaties are identical, they have many similarities, and the common protections that are provided in these treaties, I'm going to lay them out for you so you can get a better sense of what I'm talking about. So the primary protection in these treaties is that states guarantee that they will not directly or indirectly expropriate a foreign investment. What does that mean? A direct expropriation is the seizing of an asset in a direct manner. An indirect investment could be the chipping away at the value of the investment through, for example, the passage of regulations that might whittle away at the value of the company. It could be the failure to grant a license or a permit. Those are the types of steps governments have taken that investors have argued give rise to an expropriation. And for lawful expropriations are permitted under international law, but for an expropriation to be lawful, it has to be the seizure has to have occurred in the public interest under due process of law on a non-discriminatory basis and with full and effective compensation without delay. If any of those four criteria is missing, then it's an unlawful expropriation under the treaty, and investors have argued that they're entitled to higher compensation. So what I mean by higher compensation is that an investor could have purchased a property for below market value because perhaps the state was trying to incentivize the investment, and then they can claim that they're entitled to market value and even sometimes above market value at the date of the expropriation. And that's different than the compensation standards that might be available under domestic law or even under human rights law. The second provision in these treaties is what's called the full protection and security. Actually, let me backtrack. I want to give you an example of an expropriation. So let's assume that the state decides that foreign agricultural business has deprived indigenous peoples from access to fresh water, or maybe they realize that the steps taken by the foreign investors actually is harming indigenous sites. And so as a result, they deny that investor the license to conduct further drilling. The investor could argue that the denial of the license is expropriating their investment because they've been deprived of their investors' rights. The second protection I want to talk about is full protection and security, and that provision protects investors from any harm to their investment, including by non-state actors. So a common example of that is there could be communities that are protesting against a foreign investors for the construction of a pipeline because of the environmental degradation that that pipeline would cause. Think Dakota Access or Keystone Pipeline, that's in the news these days. And those protesters prevent access by the foreign investor to pursue construction. And as a result, the construction is delayed substantially. That foreign investor could argue that the state's failure to intervene and prevent the protesters or allow access of the investor to their area could constitute a violation of the full protection and security standard. Another example is the fair and equitable treatment standard. That relates to the expectations of the investor at the time that they invested. So let's assume that the state gave certain assurances to the foreign investor at the time that they were deciding whether they wanted to invest in a particular country, and they said that there will be a stable regulatory environment, a very predictable framework. This is the framework. This will be pretty much the laws that will be applicable to you, foreign investor, for the life of the investment. But then over time, communities are devastated by environmental harm and inability to access fresh water, and so the state decides to impose environmental regulations. The foreign investor could possibly argue that those environmental regulations weren't in place at the time they invested, and they didn't expect them to be, and it's therefore a violation of their legitimate expectations at the time of the investment, and they could bring a claim on that basis. The last one I want to mention is the obligation to treat investors and their investments no less favorably than own nationals or a third state. That's called the National Treatment Standard and the Most Favored Nation Standard. And in those provisions, the state is agreeing that they're not going to treat their own companies more favorably than a foreign company or an allied state's companies more favorably. But think about an example where a state decides that it wants to empower local farmers and it wants to assist them so that they can have sustainable farming. And to do that, they decide to give tax incentives to local farmers. foreign investor could argue that that's a violation of the national treatment standard because the local farmer is getting preferential tax treatment, and they could possibly sue under the treaty as well. So you could see how far-reaching these provisions are, and how what seemed to be beneficial for states in the 90s when they signed up to these treaties as a way to encourage development, economic development, create jobs for their people, has actually backfired through the overexpansive interpretation of these treaties. So I'd like to next talk about why is there a need for reform. I think it's probably clear from what I've said. But the treaty clauses have gone beyond what states intended or what they anticipated. And they've led to multi-million and billion-dollar claims that have been very difficult, particularly for small states. BITs have been used by foreign investors to inhibit environmental regulation, the protection of persons and access to fresh water, and they facilitated land grabbing in many respects. The result has been displacement of communities, and the foreign investment hasn't alleviated poverty. In many ways, it's caused it or exacerbated it. Part of the problem is the investor-state dispute resolution system. The parties to a claim, the state and the foreign investor appoint their own arbitrator, and then there is a third arbitrator. But as I mentioned, that this process has in many ways been co-opted by corporations who have selected arbitrators who are repeat players. So there are an arbitrator in one case, and they're deciding an issue or an interpretation of a clause, and then they're counsel for a different claimant in another case, where the decision that they issued in one case could be useful to them when they're arguing on behalf of an investor in another case. And there's the issue of excessive quantum, what I mentioned about the valuation surpassing what is provided for under domestic law, even under international human rights law. So the question is, what can we do? So this is the framework. These treaties have been entered into. This is the system that states have signed up to. What can be done? And there are many things, so we can be hopeful. I work with states on this issue quite frequently, and this is kind of the direction that we're moving towards, and it's a dialogue that's taking place at the UN. But with the assistance of specialized counsel, states can conduct a systematic review of all of the investment treaties that they've entered into. So you work with a lawyer, and that lawyer assesses all the treaties that this state has entered into, and determines which ones are decent treaties, they're okay in terms of the terms, which ones are expansive. Now we know we can read the decisions of these tribunals and know when certain language is used in a clause that tribunals tend to interpret it expansively. So once you've done an assessment of the treaties and you've identified ones that have some problematic language, then you can work to see, first of all, can these treaties be jointly terminated? Or, so the two states that have entered into them, can those two states agree to terminate the treaty? That's permissible under Article 54B of the Vienna Convention, the Law of Treaties. So with mutual termination, then you can extinguish the investor's rights under these treaties. Alternatively, with mutual amendment, so the two states may decide, we want to still have this treaty, we still want to incentivize foreign investment, we still want foreign investors to feel like this is a safe environment to invest in. But we want, now that we know what these clauses mean, we want to redraft them in a way that's more fair to us as well, so that we can properly regulate the environment. So through joint termination or joint amendment, two states can agree to create a more fair body of law. But that's not always possible, because recall what I explained, that a lot of times these treaties were drafted by developed states and developing states signed them. So in many instances, the chance that the developed state will want to extinguish the rights of its investors is probably not going to happen. So in that case, a state can engage in unilateral termination. So that's termination, just that one state is deciding that it wants to terminate the treaty. But it's not so simple, because while the Vienna Convention allows for mutual termination basically at any point, unilateral termination requires following the termination clause in the treaty. The termination clauses in these treaties typically indicate that the state can unilaterally terminate a treaty, that the treaty is enforced for a period of 10 years or 15 years or 20 years, and only after that period has lapsed can the state unilaterally terminate by sending a notice that they intend to terminate the treaty, and then it has effect typically 6 months later. But what these treaties also contain is what's called a grandfather clause. So if you were an investor who was already incorporated in one of the country that's terminating before they terminated the treaty, you're grandfathered in for 10, 15, 20 years. So even though the treaty is now terminated, there's a clause that says pre-existing investors and investments still can sue under the treaty for a period of 10 or 15 years after the treaty has been terminated. So with unilateral termination, the effect of the termination isn't really felt until a decade later, and states can still face claims under the treaty, so it's not the ideal avenue. Moreover, UNCTAD has estimated that by the end of 2013, more than 1,300 bits, that's over a third of them, were at the stage where they're ripe to be terminated, because recall that unilateral termination can't occur until it says the treaty is enforced for 10 years. It's only after that 10-year period that a notice can be sent. So a third of them are up for the possibility of being unilaterally terminated, but then again, remember that it may not ultimately remedy the issue, because pre-existing investors can still sue under them. So, so we talked about mutual termination and mutual amendment. We talked about unilateral termination, the pros and cons. And the third option that states can do is work with the specialized counsel to do capacity building trainings. So something like this, where there's a discussion taking place about what are these treaties, what are examples of the kinds of regulations or laws that could give rise to claims, and then when states are drafting their laws or drafting regulations or terminating contracts, they have a team of specialists in their ministries who've been trained to identify that this law actually could give rise to a breach. So let's think about a way that we can redraft it so that we don't open ourselves up to liability. So it's a way to reduce risk through checking the laws that are being drafted with respect to foreign investors against the text of the treaties to try to limit liability and limit these claims. The other thing states can do is when an investor sends a notice of dispute indicating that they're intending to sue, they can consult with their specialists to try to assess how strong or weak the claim is, and try to settle it up front before any claim is actually brought. Then the last thing that can be done is with respect to new treaties, if the state wants to enter into new treaties, making sure that they're not taking the old template that was prepared by developed states and just signing on to that again, but instead working on creating a new model bilateral investment treaty that does give them the rights and empowers states to be able to regulate. It strikes a greater balance. So that's in terms of new treaties that are entered into. And then, lastly, another thing that could be done, in particular with civil society, is to promote greater transparency in these hearings. So for a long time, these arbitration hearings were confidential, even the decisions were confidential. And so states were legislating, and many times they were legislating because that's what the public wanted. The public elected these officials because they were concerned about a particular issue, and then those lawmakers were following their mandate. But then investors would sue the state for the laws that were passed, and then there would be a confidential proceeding regarding those laws, and the civil society and voters were left out. Well, with the Mauritius Convention, that UNCITRAL transparency rules and the Mauritius Convention can now be entered into by states. so as to allow for transparency in these proceedings. That's so that these hearings are live streamed, that the submissions are available to the public, the decisions are available to the public. But that requires states signing on to that treaty, agreeing to it. And not only the treaty applies for investment treaties signed from the point of ratification of the Mauritius Convention onward, but the treaty has the states have the option of retroactive effect. So what civil society could do is encourage their states to ratify the Mauritius Convention to promote greater transparency. And where it's available to states, where these hearings are public, you can search the website of the International Center for the Settlement of Investment Disputes, which is the World Bank Arbitration Forum, and it has a list of all the cases that have been brought against which countries. And civil society can engage by identifying when their government has been sued and seeing if there's a way to submit an amicus brief or otherwise get engaged in the case when it is an open case. So just to sum up, I think today was a really important session of hearing the direct effect of what land grabbing and access to fresh water, how that's felt by local communities. There is something that can be done, and it rests in the hands of the states to engage on this issue of reforming the investor-state system and reforming the investment treaties that they've entered into. Only, my view is only from the examination of the overall legal framework that has enabled this conduct to occur and has inhibited states from being able to regulate their environment. Only from improving that framework can the issue truly be addressed at its core. Thank you for your attention.
Thank you, Christina, for the overview of investor-state treaties, as well as sort of how that can oftentimes tie the hands of governments when they're trying to uphold, let's say, the human rights even of their people, and then giving us a robust list of things that can be done. We have about 10 minutes. That would just put us over by a minute or two. And so I see that there are quite a few member states represented in the room, so I would like to first give the opportunity for any member state that wants to ask a question or make a statement at this time, and then we'll open the floor up to all. Are there any? Then, so I'll just open it up if anyone else in the room has questions or comments. Anything? Oh, sorry. Yes, Your Excellency. Professor Palau.
Yeah, well, first of all, thank you so much to the sponsors and to all of you for convening this very important meeting again with regards to the issues that are very important to addressing the issue of eradication of poverty, which is goal number one of the sustainable development, which has to do with land grabbing and with water resource scarcity from land grabbing, as we also learned this afternoon. My one sort of observation is that the government is always, at least in our experience, always in the has a disadvantage because they don't have enough money for lawyers to draft their legal arguments. And so this is the case, for instance, the tobacco industry has like $6 billion a year to market their concept, their why young people should smoke or eat tobacco or whatever. And the governments have, what, 2 million to counteract those. So what can be done with regards to this huge disparity, not just in what they have and what we don't have, but how can we, through other resources or creativity, civil society, grassroots, whatever, is there a reality that can be explored or be used, utilized? Thank you. Thank you again.
Thank you, Your Excellency.
Thank you. Thank you very much. to the organizations that have participated in putting together this panel. I have particularly appreciated the interest of each of the presentations. I'm the legal advisor of the Mission of Peru. I would like to start by saying that my country has attached a great deal of importance to, first of all, the negotiation of the 2030 Development Agenda. Goal number one has been mentioned here, which is devoted to ending poverty, is very dear to our government's policy. As you may know, the threshold of poverty has been reduced to a great extent in our country in the last 15 years. And so we are glad to say that we're doing progress there. I would like to make a question, since I'm the legal advisor of the Mission of Peru, to Ms. Ureas concerning the current reform or proposal to reform the investor statement dispute settlement system. She has mentioned, you have mentioned briefly, but I would like to seek your views concerning the proposal of having an international tribunal for investments. I understand that this permanent institution would address some of the concerns that you have mentioned, like the bias of some arbitrators that are appointed by corporations and so on. So I'd perhaps like to know your views on that topic. Thank you very much.
I'll let the panel address those, and then, or unless there were others that I missed. Okay, let the panel address those questions, and then we'll come back around and take one more round.
Thank you very much for those excellent questions. Your Excellency, regarding your question, it's really spot on, because these arbitrations are extremely costly and lengthy. They take anywhere from, one would be very short, but 1 year up until 5 years more. There are cases going on for many, many years. So they are quite costly, and the corporations are outfund the states, certainly. But I think ways of going about it, I will say the Philip Morris versus Uruguay case, my firm defended Uruguay, as I think you know. And in that case, not only did we defeat the claim in full, but we were also awarded all costs, including legal fees. So in the end, Uruguay paid nothing. But of course, in those cases, you have to win and recover your attorney's fees and costs. But that's kind of goes hand in hand with working with law firms that are committed to the defense of states and who have done this many, many times and who know the ins and outs of the legal arguments and who can do it in a more efficient manner. But of course, that does cost something. And so some ways of going about it is looking for foundations that care about these issues. For example, the anti-tobacco, there's a whole number of organizations who are concerned about these issues, or in extractive industries, the Soros Foundation or Gates Foundation. So I think that there has to be greater cooperation between the various foundations that are trying to promote certain social issues and the states who are trying to defend against their right to properly regulate. For Mr. Horna, thanks also for your question. With respect to a regional tribunals or permanent investment courts, I think it's a very good idea. And I think it's a good idea for some of the reasons that you point out and that I mentioned in the talk, which is that there is this issue of repeat player and the bias that can occur when arbitrators are serving both as counsel and as arbitrators, and there may be some incentive to a certain interpretation of a clause. That's not the case, of course, for all arbitrators, but this does occur, and it is possibly even non-intentional in many cases for these arbitrators. But a permanent investment court where it would be a group of judges who would have been elected or appointed by states through the UN process, they would have been elected They are not permitted to serve as counsel. Their sole job is to serve as a judge. They have a long term, and then they are experts in the field, so it allows them to really hone down on these treaties, understand a number of the treaties, and decide them in a manner that there's some consistency and where there isn't the bias of wanting to ensure that they can properly represent their party when they are working for the claimant. So I think it's an important discussion taking place at UNCITRAL in the 6th committee, and I think we need to advance that. I think it will take a while to set that tribunal up. If it does happen, I can't imagine it happening for another, like the soonest 5 years, probably 10 years. So something needs to happen in the meantime. But that's very important.
Are there any other questions or comments? I know we're going over time a little bit, but I want to give people an opportunity. In that case, we'll let the panel give a few last comments, and then we'll call it.
Yes, I think there is one point coming up quite clearly. We are talking about the problem at two different levels. The level of civil society, the peasant, the people involved, and the states. Because as she pointed out, often the land grabbing is done where the traditional and the custom laws are still in place, and where the local people do not know the implication of the international laws. And then there is another, I'm sorry for the representative of the states here, but there the other side, it is the corruption. There is so much money in this issue that the corruption going through. For instance, I'm not sure, I don't approve, but I read that the World Bank sent down a team of lawyers to Africa to push the government to change the constitution, just to open the door to all these problems. So I think we have to work, as they pointed out, and a global strategy where the people on the ground become aware of the problems going on. In Guatemala, for instance, the people are fighting among themselves because some of them don't want to sell or seize the land, but the others, facing the money the government or the corporation are giving them cash, they agree. And then the other level of the states that become aware that the future of their population.
Yeah, I also like to bring the two examples I was showing you. One, Vedanta company, and another the POSCO, one of the Korean company. See, in the beginning with the government, okay, Indian government and state government, they made the agreement, and so that was okay in their part. But from the point of the local people, villagers, no, so many villages, say 20 villages. So the local government, neither the company, they did not take care to consult, to inform, to sit together and to have dialogue and other things. Nothing happened. Then finally the people resisted. Even some of them they died, but they continued to fight till, say, for POSCO, almost 13 years. They continued to fight. They did not allow the company, the state to come in and to take the land. So instead of all these things, suppose the state or the company, they could have sat with the people, they could have taken their opinions. I think that way how the resolution, they could have made it, instead of keeping them so much of tension for so many years. So I think those type of things also, as a civil society members, how we can take into account and how we can make aware of the people and the government itself. So I think that is very important matter.
Sorry, there's a.
I have a practical request. Would it be possible to have the PowerPoints that were presented today perhaps forwarded to the mining working group and people could access them from there?
And also
That's all right with you?
also the talk of Christina, your talk.
Talking points? Sure.
Yeah.
Did you want to have any concluding remarks?
I don't have any.
All right, thank you, everybody. I'm sorry we went over. Thank you for your attention.